You secretly recorded your doctor on audio using your iPhone. And now he said something extremely damaging where he basically admitted that he screwed up. Can you use that audio conversation at the time of trial without ever having to disclose to the defense that you have that? You want to use it to ambush him. Can you do that? You want to know the answer? Come join me for a moment as I share with you some terrific information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now you had surgery and your surgery goes horribly wrong. And now a few months afterwards, a few months post-operatively, you go back to the doctor for follow-up. And during the course of that conversation, you now get the doctor to actually admit, to say, yes, I'm sorry, I screwed up. Something happened, I wasn't paying attention, and all because of that, you now suffer these terrible injuries. What you didn't share with the doctor during that conversation was you were recording the entire conversation on your iPhone. You were recording the audio portion. And now you got him to admit that. So now you decide you want to sue the doctor, claiming that he was careless and that his carelessness caused you all these terrible injuries. And now your attorney goes ahead and gets your records reviewed, and your expert confirms that yes, in fact, the doctor was careless, that he violated the basic standards of medical care. And as a result of that, you suffered significant harm and injury, and your injuries are terrible. So now, you have this great piece of audio. You tell your lawyer you've got this great piece of audio, and you're hoping to use this to spring it on the doctor at the time of trial. Why? Because after you start your lawsuit, the doctor and his attorney tell your lawyer, listen, why are you suing us? We did nothing wrong here. We did absolutely nothing wrong. We did everything by the book. And by the way, if we did something wrong, so did you, Mr. Patient. And by the way, if we did something wrong, whatever we did didn't cause or contribute to your injuries. And then, you know what? They say, if we did something wrong, well, guess what? And it did cause your injuries really aren't as bad as you claim them to be. So those are the typical defenses we hear from the doctors and their attorneys. So now, again, they say, we are never going to settle this case. We will see you at trial, they tell us. Okay. Well, in New York, a medical malpractice case takes 2 to 3 years from the start of your case all the way to the time it gets to trial. So your case goes the distance. And now, at the time of trial, you want your lawyer to use this audio to tell the jury, to let the jury hear this audio. So now they'll know that, yes, your doctor actually admitted that he screwed up. But you don't want your attorney to tell the defense lawyer that he's got this audio. Because doing that, you lose total surprise. Can your attorney do that? Can he take this hidden secret recording and now spring it on the doctor at the time of trial without the attorney ever knowing about it, without the defense lawyer knowing about it? The answer is no, you can't. You cannot do that. That's not how it works. That's not how any of it works. If you have such damaging information, we are required to notify the defense that we have this. If this is a smoking gun type of piece of evidence, okay, where the doctor clearly admits, yes, I screwed up, I violated the basic standards of medical care, I was careless, I was doing something I shouldn't have been doing, and as a result of that, you now suffer these terrible injuries. That's an admission. That's a very important thing. That's something that we want to be able to use, not just at trial, but at the beginning of the case or in the middle of the case, to ask the judge for what we call a directed verdict. Now, a directed verdict is simply trying to short-circuit part of the trial. If the defense said, hey, we did nothing wrong, we'll see you at trial, well, that information may be so useful, it may be so helpful to get us to show to a judge, hey, judge, we don't need a trial on this issue to see whether or not the doctor screwed up. The doctor admitted himself he screwed up, and we have the evidence to show it. If we have this smoking gun type of evidence, why don't we actually give it to the judge on a silver platter, together with medical expert support and evidence, to say, Judge, we don't need to go to trial on this issue to show that we are more likely right than wrong, that the doctor screwed up. We actually have the evidence in the doctor's own words that he screwed up. Here it is. Listen to the audio yourself. And now, what happens? Now the defense has an opportunity to go ahead, obviously to listen to the audio, because we have to provide them with a copy of it. Now they have to go ahead and defend what the doctor said on that audio. And they'll do it a couple of different ways. Number one, they will fight the authentication They will fight to say, hey, listen, we don't know whether or not this is truly the voices that they claim it is. We don't know that. At least that's what the attorney would argue. So they'll fight that this audio is actually authentic. Then they'll go ahead and argue the facts of what's contained in the actual audio. Judge, what he said in the audio is not really what he means. It's subject to interpretation. He was simply apologizing for the after effects of what this patient had to go through. And the defense lawyer will do everything possible to minimize the effect of this particular audio recording. So that's an interesting way to get that information in front of the judge before you ever get to trial. You want to short circuit that if possible. Because if the judge agrees with us that the doctor admitted in his own words that yes, there's no issue to be discussed here at trial later on, yes, you get a directed verdict in your favor showing what? That the doctor was careless. Okay. Now the next thing we'll have to decide at the time of trial is whether his carelessness was a cause of your injury. The judge may or may not believe that it is. If the judge says yes, the doctor admitted in his own words that he was careless and that his carelessness caused your injury, terrific. 2 out of the 3 elements that we need to show at trial have already been established. So that means the only thing left for trial would be damages, to discuss the extent of your injuries. So we would put on treating doctors, we would put on physical medicine and rehabilitation experts, we'd bring in economists to talk about the value of money, that $1 today is different than the value of $1 10, 15, 20 years from now. And then the jury would only be asked to decide how much money you are to receive for all of your damages, for all of your harms, for all of your losses. That's entirely different. So if in fact you do have an audio recording where your doctor actually admits in his own words that he was careless and his carelessness was a cause of your injury, now you may already be ahead of the game. But going back to the original question I asked at the beginning of this video, can we use this audio recording to spring it on the defense at the time of trial? The answer is no. If we have not shared that audio recording with the defense, it will not happen. You want to know why? It's because this would be unfairly prejudicial to the defense. This is the first time they're hearing of it. They didn't know anything about this. And now we can't go ahead and do a trial by ambush, not like it used to be 20, 30, 40 years ago, where this used to happen regularly. So the courts did away with that. So if we want to use that piece of evidence, we have to disclose that and turn it over to the defense early on in the case. This way they can go ahead and digest it. They can go ahead and try and fight it. They can do everything to show that it wasn't authentic. And now they're going to have to fight it when we ask the judge to give us a directed verdict because of what's contained on that audio recording. So why do I share this great information with you? I share it with you just to give you an insight of what happens from time to time when this comes up. It doesn't happen often, but when it does, it becomes very interesting. You know, I recognize you're watching this video because you likely have questions or concerns of your own. Well, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need answers, what I encourage you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.